Okay. Welcome everyone to Guardianship, a presentation by CARD. And I am Denise Barnes. I've been a CARD consultant since 2013. Working up on year 8 pretty soon, so that's going pretty well. We're going to talk about guardianship, and it's not a formal presentation, so if you have any questions, please feel free to hold them until we have the question and answer period at the end. I do, well, I had some poll questions that I thought would be here, but they're not there. So just out of curiosity to let me know where everyone is from, can you type in the chat box where you're watching us from? If you don't know where the chat box is, if you go up to the top of your controls and hit the 3 dots, chat is the top choice that is there.
Want to try it?
I appreciate that so much.
Try cottage cheese. Do you like it?
And so we have all over Florida.
Okay.
It's pretty cool.
I'm here shortly.
Okay, well, thank you all for doing that. Continue. Just want to remind everyone to get 15 minutes of sunshine every day to keep you healthy. Put a smile on your face, even though it's raining here where I am. But make sure you get that sunshine every single day. Just want to go over a few tips to for us to have a successful webinar today. If you need some support during the webinar, please select chat from the bottom or top bar and put it in there, and I will attempt to assist you as best I can. Chat will not be allowed between people. You can only chat to me, not to other individuals. You can't share your screens. During the presentation, if it starts to buffer, I may ask everyone to disable their video so that it will preserve the bandwidth and you'll be able to hear the presentation for the entire presentation. So again, welcome to this presentation. I need everyone to mute their phones. I will handle it. Thank you. Melissa Go, I see that you have your hand raised. Do you have a question? You have to unmute yourself.
Oh, no, I have no questions yet. Sorry, I didn't know that was on there.
Okay, thank you. So to continue, I am coming to you from the Center for Autism and Related Disabilities at USF. We are a DOE funded agency, and we provide our services for free. We provide our services for CARD-USF, provide services for 14 counties. There are 7 CARD centers statewide, and so every resident of the state of Florida has a CARD center that can assist and represent them. We work individually with individuals on the spectrum, with agencies, with institutions, and families, and our services are of no charge. I will put these links in the chat area later. These are some quick links to our CARD information and resources so that you can access that information as accurately as possible. And hold on. You guys are not hearing that, so hold on just 1 second. I know what I did wrong. I didn't connect computer sound. We're going to have several videos that I'm going to show today, and this is the first one. I still don't hear the sound. Did you guys hear the sound?
No sound, Denise.
apologize for this first video. I've been having technical difficulties all day with my headphones. I will try to get that video up and running before the end of the day because I know another way to find it. So today we're here to talk about guardianship. We're here to talk about the human rights of your individuals on the autism spectrum. And in talking about guardianship, you may hear several other terms. Guardian, you may hear power of attorney. You also may hear the age of majority. And we're going to go into these a little bit so that you have that information for yourself. So human rights are defined as a moral or legal entitlement to have or obtain something or to act in a certain way. Wikipedia says that human rights are legal, social, or ethical principles of freedom or entitlement. These are rights that are fundamental, normative rules about what is allowed of people or owed to people according to some legal system, social convention, or ethical theory. It is important that we distinguish between these three terms during this seminar. A parent is related to either the child through biological or adoption. A guardian does not have to be directly related to the child or adopted or have adopted him, but has to make all legal and pertinent decisions pertaining to a child's education and life. A guardian, as defined by CARD.USF says, is a defender, a protector or keeper, a person who has been appointed by a judge to take care of a minor child or incompetent adult personally and manage that person's affairs. Power of attorney is a legal document giving one person, the agent or attorney in fact, the power to act for another person, the principal person. The agent can have broad legal authority or limited authority to make legal decisions about the principal's property, finances, or medical care. The age of majority is the threshold of adulthood as recognized or declared in law. It is the moment when minors cease to be considered such and assume legal control over their persons, actions, and decisions, thus terminating the control and legal responsibilities of their parents or guardian over them. And there are some other definitions that are important during this seminar, and they are healthcare surrogacy or advanced direction. A healthcare surrogate is a person that you authorize via a designation of a healthcare surrogate form to make medical decisions for you when you are unable to make your own decisions. Durable power of attorney is a legal document that states in the event that one becomes incapacitated and unable to handle matters on their own, they assign who will handle those matters for them. A living will is also can also be called a directive to physicians or an advance directive. And it is a document that lets people state their wishes for end-of-life medical care. A medical proxy or healthcare proxy, sometimes called a healthcare surrogate, or durable power of attorney. And that comes into play when the person becomes incapacitated. Representative payee. A representative payee or substitute payee is a person who acts as the receiver of United States Social Security disability or supplemental security income for a person who is not fully capable of managing their own benefits. And a guardian advocate is someone who has been court appointed to advocate for that person for maintaining the rights of the individual. Guardian letters of guardianship are formal from the court and have to be filed and renewed periodically. A living trust is a trust that is set up for an individual to make provisions for them for the lifetime of that individual in case something happens to the individuals who are donating the money for that trust. Their estate are their personal items and belongings and their finances. Able Trust is an agency that can help you set up a special needs trust and also additional trust for the care and support of the individual through their lifetime. And a special needs trust is also set up in such the same way. With the able trust and the special needs trust, you have to specifically state what the funds are going to be used for, and someone oversees that to ensure that those funds last the lifetime of that individual. So there's 5 important legal terms that you need to be familiar with when it comes to guardianship. And I'm going to show a video from YouTube that talks about those.
Hey, this is Steve, and I'm hanging out in the yard with Olive, and we're talking guardianship legal terms and glossaries. Based on my experience representing clients in guardianship cases, here are the 5 terms that you need.
Sorry.
Hey, this is Steve, and I'm hanging out in the yard with Olive, and we're talking guardianship.
Sorry, I admitted someone and it started.
Hey, this
over.
is Steve, and I'm hanging out in the yard with Olive, and we're talking guardianship legal terms and glossaries. Based on my experience representing clients in guardianship cases, here are the 5 terms that you need to know. The ward. The person for whom the guardianship petition is filed is called the ward. In the case of special needs parents, this is your child. The ward is one of the most frequently used terms in a guardianship proceeding. For a parent, it sounds a little, well, cold, even demeaning. But don't take offense to it, it's just the court's way of identifying a person who's the subject of the guardianship. Petition and petitioner. When people use the word petition, frequently they're talking about a document that many people sign to get some authority figure to make some kind of change. It tends to have a somewhat negative connotation. In the case of guardianship, petition is merely a fancy word for an application. It's the formal written document you file with the court that asks the court to begin a guardianship process for your child. As the person filing the petition, you may be referred to as the petitioner. In the context. Hey, this is
I
Steve.
apologize.
Negative nor positive. Letters. This isn't a note that you send in the mail to your cousin. Letters is the official legal document given to you by the court when your application for guardianship, remember that's called your petition, is approved by the court. The letters, also called the letters of guardianship, is a document that you'll bring with you to doctor appointments and meetings with other important people with whom you'll deal with on behalf of your child as their guardian. Guardian advocate. You know that you need to get guardianship for your child when they turn 18. But what you may not know is that if your child has a developmental disability, there's an expedited process for getting guardianship in Florida called Guardian Advocate. You end up with the same rights as a traditional guardianship, but if your child has a disability such as autism, spina bifida, Down syndrome, or an IQ lower than 70, the judge can grant guardianship from a doctor's diagnosis and an IEP as opposed to appointing a panel to determine your child's competency. Oh, and one more thing. Unlike traditional guardianship, in most cases, there's no need to hire a lawyer to become a guardian advocate. Oath. Many of the documents you file with the court must be signed under oath. What's important about this isn't the procedure for signing, but the consequences for lying. You'll have to answer many personal questions in your guardianship application. Always answer truthfully. If it's discovered that you intentionally lied to the court, you can be subject to criminal prosecution for perjury. There are dozens of other terms you should be familiar with. Check them all out in our list below.
So I've learned during this webinar that I can't do anything else on my computer or it stops videos. So I apologize for that. So now we're going to talk about least restrictive and for guardianship. So before you consider becoming a full guardian for your child, consider that if you put in supports for each of these areas in this pyramid, that you may not need to go to full guardianship at some point. And so supported decision-making, helping them learn how to make their own decisions, putting in supports for them to be able to do bank services that can be done in a least restrictive way than guardianship. Becoming power of attorney is least restrictive than guardianship as well. Being their rep payee for their Social Security benefits is less restrictive than being their full guardian. Having advanced directives put in place, having medical proxies, setting up trusts, these are all things that are least restrictive than becoming the guardian for an individual. Guardian advocacy is less restrictive than full guardianship because it still allows the person to maintain some rights and it doesn't label them incapacitated. And guardianship requires that the person be fully labeled incapacitated, and it restricts a lot of their rights that they may have. So making your own decisions with the assistance of others, sometimes referred to as supported decision making, can be an option. We've talked about most of these other things on here. Guardian advocacy is something that's unique to Florida, and it's an alternative to guardianship that is only available to individuals with a developmental disability. This option generally takes less time and is less expensive. Under Section 393.12 of the Florida statutes, the individual must have a diagnosis of a developmental disability and must lack the decision-making ability to perform some but not all tasks necessary to care for his person or her person, their property or estate. Guardianship advocacy is established through a court process. Letters of guardianship advocacy are issued by the court identifying which rights have been removed as well as which rights are delegated to the guardian advocate. And while there are a few differences between guardian advocacy and guardianship, the authority given by the court and the powers and the duties defined in the statutes are the same. And option 9, which is guardianship, is the most restrictive for decision making. And there will be a link to this video that will be posted. I'll make sure that you guys all get that. So here's one of our final videos talking about guardianship. And I do the videos because it's a visual.
Guardianship is the court-supervised process of handling the affairs of an incapacitated person. An incapacitated person can be a young person under the age of 18. They could be someone with developmental disabilities, so they can't completely handle their own medical and financial decisions, be at any age in that case, or it could. Guardianship is the court-supervised process of handling the affairs of an incapacitated person. An incapacitated person can be a young person under the age of 18. They could be someone with developmental disabilities, so they can't completely handle their own medical and financial decisions, be at any age in that case, or it can be, more typically, an older person that is suffering the infirmities of aging. That's the typical guardianship that we get involved in. People consider guardianship when a family member starts seeing their loved ones slip. We can see a guardianship sometimes coming from far away and anticipate it, maybe a year or two in advance, so we get ready for it. But we'll advise the family member on how to best deal with the situation. If a guardianship is required and we're representing the guardian, we'll tell them all the steps that are necessary to begin the guardianship. Later, we'll be advising them on how, after they're appointed, to make a report to the court. And then there will be yearly follow-up reports to the court. Sometimes we represent the ward. In that case, we go out to see the ward and see where they're living and make sure their environment is safe and make sure that they're happy and feel the necessity of the guardianship. Many times the ward will feel that the guardianship is unnecessary and that they can handle their affairs on their own. And in that case, we'll let the court know and let the court make a decision. And then also there are disputed guardianships that are in front of the court, and we can represent parties in those.
And that guardianship video was produced by Estate Planning and Elder Law Center of Brevard County. And someone asked a question, will there be a link to the video on the YouTube channel as well? Yes, you will all get a copy of that information after the presentation. So alternatives to guardianship, as I said before, include supported decision making and all those things that were on the pyramid. Person-centered planning is also a great alternative to guardianships. Guardianships are court-appointed. They can be voluntary or involuntary, and involuntary is when the person is deemed incapacitated, and there will be a transfer of rights from the person with autism to the guardian. And then guardian advocates, they're also court-appointed, and you are trained to provide guardianship without the removal of the person's rights, and it can be done without an attorney, and it's the cheaper alternative as well. That video worked yesterday. Sorry about that. Here's a video on power of attorney.
There's something about the word power that is so, well, powerful. Just ask those who wield it. They'll tell you there's a lot that comes with having power. One type of power that has substantial ramifications is the power of attorney. A power of attorney is a written document where one person appoints another person to act as an agent on their behalf. The person appointing the power to the agent is called the principal. And by doing this, the principal gives the agent authority to perform certain functions or acts for them. The specific authority a power of attorney grants depends on the specific language in the document itself. This can be giving someone final say over things like financial matters, healthcare decisions, legal choices, or even the sale of a boat. Power of attorney can also allow the agent access to bank accounts or personal files, and the ability to sign contracts. For a power of attorney to be valid in the state of Florida, it needs to be signed by the principal with 2 witnesses and an acknowledgement from a notary. Though there are exceptions regarding military powers of attorney and out-of-state powers of attorney. One special type of power of attorney is called durable power of attorney. These contain special language to make sure that they survive the incapacity of the principal. Most powers of attorney granted today are durable. LegalU provides free, automated forms for you to use to create your own power of attorney, fast and easy. And LegalU attorneys are always a phone call away to answer any questions you may have about these important documents. LegalU, you can do this.
And we are not advertising for LegalU, just letting you know that there are online versions of the power of attorney that you can access. So Florida law provides for 3 broad types of guardian. Non-professionals, which are usually called family guardians or guardian advocates, who may act on behalf of his or her family member or friend who can serve up to 2 people. Professional guardians can serve 3 or more persons and are usually compensated for their services. And public guardians must meet the same requirements as a professional guardian and can only serve persons with limited financial means who have no other available person to serve as a guardian. Persons who serve 2 or less wards are required to complete 8 hours of court-approved training. And each professional guardian and public guardian must receive a minimum of 40 hours of instruction and training. Ward or guardianship of the estate or property can also be assigned. Non-professionals or guardian professionals have to get that training, and guardian advocates have to get that training. And DCF offers free training for guardian advocacy, and I will provide those links to you at a later time. So rights that may be removed by the court under guardianship proceedings. Delegable rights are marked by, and they're not marked by an asterisk. So they have, individuals will still have the right to apply for government benefits. They will still have the right to manage money and property or make dispositions of property. The right to determine their residence, the right to consent to medical and health treatments, the right to make decisions about social environment and social aspects of that person's life, the right to contract, defend lawsuits, the right to marry. If the right to enter into a contract has been removed, the right to marry is subject to court approval, as marriage is a contractual right under the Florida law. The right to vote, they have the right to have a driver's license, the right to travel, the right to seek or retain employment as well. Rights that can never be removed by the court. include being represented by an attorney, to have access to the court, to have a proper education, to be free from neglect or abuse and exploitation. They have the right to remain as independent as possible, meaning they have the right to be in the least restrictive environment as possible. They have the right to receive the necessary services and rehabilitation needed to support them to be as independent as possible. And they still maintain the right to be treated humanely and with dignity and respect. And CARD has a lot of resources, including our Age of Majority Toolkit, which is going to be provided in the links. And it's also listed on our resource page site. Any questions? No questions? Okay. Let me go back to this. There's an online survey that I need you guys to complete. And I will put the link in the chat box. And while you guys are completing that, I want to share with you a few things. So during the month of July and part of August, we're doing a summer safety series, and we're doing it in conjunction with USF Health Service Corps. We're doing it in conjunction with Safe Kids of Greater Tampa and Safe Kids Suncoast, as well as the St. Pete Fire Department. Our next topic is going to be the St. Pete Fire Department Fire, Home, and Safety, which will be Thursday, 8/6 at 7 p.m. We are also going to redo Josh the Baby Otter on Monday night at 7 p.m. And I will make sure that you guys all get that link and get copies of these flyers. I'll send an email to all of those who attended today.
It says the survey's closed.
It says the survey is closed. Okay, what I will do is I will email you the updated link for the survey. I apologize for that. Thank you. We also have coming up Arts in the Park. It's going to be activities, music, dance, and art competitions, and it'll all be virtual. And that's going to be on July 31st from 3 to 5 p.m. via Zoom. We also have that same flyer in Spanish that talks about all the things that are going to occur. You probably have already received this flyer, but we have some other parent caregiver trainings that are coming up. On Friday at 1 p.m. we'll be doing transition and employment options. On the 24th, we'll do resources when you turn 18. On the 29th, we'll do activities for teens, and then transitioning to adulthood will be on August 7th at 6 p.m. In our adulting series, we will have navigating relationships and friendships on August 10th at 6 p.m. And our website is listed here. Our phone numbers are there. We're all working virtually now, but we are all answering the lines and answering all emails when they occur. No other questions? There's one question that says, if granted power of attorney or guardianship, does that have adverse effect on Social Security? No, it does not. For Social Security, you would have to be considered their payee, and it does not affect their Social Security if you are the power of attorney or guardian. You do have to report more information in regards to their Social Security if you have power of attorney or guardianship to the courts. Those are all the questions. When the person turns 18, yes, Adrian, you are correct that once the person turns 18, they no longer look at the parental income, but they do look at how much that person is contributing towards the household income. So when they turn 18, you do need to potentially charge them some rent for them to get the full amount. Do the documents for the job of power of attorney have to be filed with the court? Yes, they have to be filed with the court. What's the average cost for attorney fees? For guardianship, attorney fees can range from $3,000 to $9,000. Most of the families that I've worked with have paid at least $6,000 to use an attorney to file for guardian. But if you do guardian advocate, then it's just the filing fees for the forms that you have to turn in and the certification that you get. Generally, how long does the process take? Guardianship can take anywhere from 3 months to a year. It depends on the documentation you're using and the process that you're going through. You do need to use if you're going to use an attorney, it has to be one that is allowed to file petitions and do court proceedings in that county. So I would recommend that you do not wait until the day before someone's going to turn 18 to start filing for guardianship. It's a process. You want to start early. Vanessa asked, should you apply for guardian advocate before they are 18 or wait until they are 18? What I would suggest that you do is you start taking the guardian advocacy course trainings and filing the paperwork prior to them turning 18, so that around the time that they're turning 18 or shortly thereafter, you can be assigned as the guardian advocate. Any other questions? So here's my email address if you have any other questions about guardianship. Feel free to send them to me. I will be sending out a follow-up email with you guys. I will make sure that all your questions are answered. I will also send you the flyers from today and a copy of the PowerPoint presentation. And I also have a guardianship resource that I will share with you, and I'll go over it real quick. So you'll get this document in an email, and it's all guardianship resources. Florida Wings has a decision-making option and a process to help you decide if you need to be a guardian advocate, or a power of attorney for an individual. And then they have a lot of resources to help you to develop abilities in that person and to get their rights restored. The FDDC is the Florida Developmental Disability Council. They have a manual and a workbook in English and Spanish called Lighting the Way to Guardianship and Other Decision-Making Alternatives. And they have an online training as well that's designed for individuals and families to help you understand the range of decision-making options for an individual. They have some fact sheets for educators, students, and parents. And they also have a workbook. The National Council on Disabilities has Beyond Guardianship, talking about alternatives to promote greater self-determination. Pathfinders for Autism also talk about alternatives to guardianship. And the Guardianship Project has a glossary of terms in regards to guardianship, and also supported decision-making. The Department of Elder Affairs has a lot of guardian resources, especially if you're looking for a professional guardian. They have those resources available. the guardianship statutes is chapter 744 of the Florida statutes. There are, the STAR tool is a way to help people to be supported and safe and secure while living in an inclusive and community environment, and that's offered by the DC Department on Disability Services. And then there's the Florida Bar has information about power of attorney and sample forms. I talked about the guardianship advocacy. DCF has a guardianship advocate training and a resource manual, and they have it in both English and Spanish. The Pierce County Law Library talks about guardianship alternatives, and that's the video that I showed, one of the videos that I showed to you guys. And then on this, I also have each individual county and the links to the court guardianship information for that county. And you all will get a copy of this in an email. And then if you wanted to, I'll also have a link for you to be able to download or share additional information about this. Okay, I have a couple more questions. It says, if you're granted guardianship and power of attorney, are you still able to claim the individual as a dependent on the taxes? You should only do one, not both. Guardianship is more restrictive than power of attorney. And if you are, if they're over the age of 18 and on Social Security, they would file their own income tax information. File their own income tax state forms for themselves with the assistance of their guardian or power of attorney. More specific information on Florida guardianship advocacy. Ellen, can you explain what that means?
I think you already answered it, and I think it'll come in the email with those resources you gave me.
Okay.
Thank you.
Thank you very much. And what if the person turns 18 before you file? What happens to them? Usually nothing happens to them. It just so happens that if you are going to file for power of attorney for health and medical and financial stuff, or you're going to do guardianship for those same reasons, if something comes up tragic where they need surgery or something like that, because they are over the 18, because they are over the age of 18, they can choose to have those services done or not. They have a voice, they have a say, but we're not wishing that on anyone. So really nothing really happens. It's just that they're allowed to make more decisions. If they're still in school, the schools will defer to the person before they defer to you. They'll have to get permission from the person to share information with you. In regards to school, medical providers will have to do the same thing to share information with you. But you can have a power of attorney set up for that person on the day that they turn 18. It's simply a form that you download off the internet, fill in, check off the rights that you're gonna have for that person. And then you need to share it with the school, you need to share it with the bank, you need to share it with their medical provider to make sure that you stay in the loop for those items. There's a question: my daughter has Down syndrome and will not be able to make decisions over her own probably ever. Will being an advocate be okay, or am I better off taking total guardianship? Being their guardian advocate, I will always say it's going to be better because it's the least restrictive, and it allows you to do the exact same stuff, but it maintains some of the rights of the individual. Any other questions? Well, I want to thank you all for joining in this hour of knowledge and power on guardianship from CARD, the Center for Autism and Related Disabilities at USF. You will get a follow-up email with the guardianship resource, the link to it, the link to our Age of Majority Toolkit. You will also get the link to the survey. And if you have any other questions in regards to guardianship or have any other topics that you'd like to see us cover, please feel free to email me and let me know. I thank you all. Have a great day. Remember to get 15 minutes of sunshine. Those who haven't done it yet need to go stand outside for 15 minutes when it stops raining. Have a great day.